In this segment, we'll discuss about client disclosures. In the last segment, we looked at what an IP client generally is, the types of clients that are actually coming before the clinic. In this segment, we'll be discussing a little bit more as to when you actually sit down with a client, what do you do? Now, at the outset, I want to indicate again, what is the end goal here? As we indicated in the last segment, the end goal is that from the client disclosure, you are in a position to proceed forward with actually doing the legal analysis on their behalf. And if we have a faulty foundation, no matter what it is we do thereafter, it will be faulty. So we want to make sure that our analysis is spot on. And in order to make sure that that analysis is spot on, we need a foundation that is completely solid. Now, I would indicate that prior to actually even sitting down to that client disclosure, it is extremely helpful to go ahead and send the client some type of invention disclosure form or a trademark disclosure form. And these forms can be sent to the client, and you can request these forms be returned to you sometime prior to, for example, the client disclosure. And one of the reasons for this is that if you go ahead and let's say just jump in and have the client disclosure immediately, you may not necessarily even know where to begin. And to give you a more concrete example, there was one time where I was working at having a discussion with a potential client relating to their invention, and their invention related to undergarments that were being used to detect cancer. So it was cancer detecting undergarment type technology. And to be blunt, that was completely out of my field. Yes, I do have some of a background looking at biomedical type products, and I studied that a little bit in school. But the reality is that the mechanisms and sensors that are being used to actually detect cancer in today's market, that was out of my field. So what did I do? With that information, I was able to go and do some research. I was able to prep myself so that when I sat down with a potential client, I was prepared. I could actually talk, so to speak, a little bit their language. Why? I'd done my own prep work to be able to come up to speed. Now that's very important whenever it is that you meet with these clients, and these pre-disclosure forms will allow you to have some context or base or background by which you can do a little bit of an inquiry yourself so that when you sit down with them or talk with them, you're able to actually speak their language a little bit. So first off, these disclosure forms, the primary reason is so that you are aware from their point of view of what is really new, of what is being used. And not only that, but you get their opinions as to how does this even differ from what is out there. And with this type of information, you can then proceed forward and actually do your own background. You can look into the technology that will be discussed. Now, I would indicate also a little caution here in that, even going back to my prior example, cancer detecting undergarments, I literally could have spent weeks, months just studying everything out there in the field alone. And the goal of this is not necessarily to know everything, because the reality is that the inventor or the business person that will be sitting before you is supposed to be the expert in their field. They are the inventor, they are the business person, they are aware often of what the competition is. So your role is not necessarily to know everything there is out there relating to their particular technology. Your basis is to be able to have some contextual understanding of what is out there so that you can frame properly what it is that they have invented or what is being used by them. And so again, going back to the example of this cancer detecting undergarment, yes, I could have spent weeks looking at it, but what did I do? I spent a few minutes coming up to speed, and by a few minutes I mean probably less than 15 minutes, looking at the market. Was anybody even selling cancer detecting undergarments? What types of fabrics were being used that would allow for those types of sensors? And not only that, but to a certain extent, you want to be very careful that you're not diving in too deep. And one, with respect to time, as I indicated, but the second reason is because anything that you find potentially may have to be disclosed to the patent office. And so the goal of this background type research, again, is just to skim the surface sufficiently that you can speak the language. Let's assume that, for example, the client that was coming before us had camera-related technology. Well, and let's assume that you have never dealt with camera-related technology before. So you go online and you say, oh, okay, there's a camera. There's usually some type of an image chip or image sensor related that sends information to an image chip. There's usually some type of lens that focuses the light onto an image sensor that then transfers it to a chip. And there's usually some type of some lens assembly that is the receiving unit to actually taking the light, focusing it on the sensor that then sends it to a chip. So at the end of the day, what we've done is simply come up to speed so that if somebody says lens, sensor, chip, we have some understanding contextually what it is they're talking about. Do we know everything about each of those three fields? No. And well, what if they come to the meeting and they start saying, well, the aperture of the lens allows us to more acutely focus the light going into the image sensor, and you may have failed to in fact even look at what an aperture is. So my point is that you want to know enough of the terms that when they start using the terms, you have some context as to where it is that fits into the overall structure. The second thing I would indicate with respect to doing this background research is I do not expect you to know everything. And there is nothing wrong with actually saying that at the client disclosure. Now, you may be saying, well, aren't they coming to us? And if I tell them I don't even know what they're talking about, that's kind of an indication to them that I may not really be qualified? And the answer to that, one, is yes. If you indicate that, that does indicate to them that maybe you are not as up to speed on that technology. So there is some importance with coming up to speed just sufficiently that you understand kind of the basics. But the second thing I think is equally important, and that is that if you go ahead and you start proceeding along this lines of talking about it, you want to make sure that that what you are communicating about with the client instills in them confidence. And one of the best ways to do that is to simply be honest. Now, you may be saying, well, isn't that kind of obvious? And I would say yes, but you'd be surprised how many practitioners do not do this. And by do not doing this, I mean, let's say the aperture came up at your client disclosure. And there's a few ways of saying it. You can say, you know what, client, I don't even know what you're talking about. I've never even looked at camera technology. Can you please give me some background here? Now, that would be an approach that would communicate to the client, you're not really up to speed on some of the basics. There's another way of saying it. Let's say that you're sitting before them and say, you know what? And this is a very good background section. Can you please, at a high level, just give me a definition of aperture? That way I understand contextually how it fits to everything else that you have just described. And so what you've done with this approach is you, in essence, have asked them for their input on how it is that they would define a known term, aperture. It's a very easy way, in essence, of simply getting their information without necessarily telling them you don't know what in the world they are even talking about. A third approach is simply to say very succinctly, you know what? I have done some background, and sometimes even with client disclosures, I start like this. I say, you know what? Prior to the meeting today, I did some background on camera technology to make sure I had some basic understanding of what it is that we would be discussing today. But you just used a term aperture that I'm not familiar with, and that did not come up in my background research. Can you please give me some more context as to what it is you mean by that term? And so what you've done by this approach is simply you are fully honest in indicating, one, that you have tried to come prepared, and that signals to them that you really are trying to make some effort. And two, that when you legitimately do not understand something, that you indicate that. And to a client, that gives them this great sense of confidence that you know what? You are not a fake. You're not trying to put on some face, that you are not trying to be something that you are not. And that is, I think, one of the most important things that we need to learn. is being willing to recognize when it is that we don't have the answer, being willing to recognize when it is that we don't understand what is going on, and being able to point that out to the client in a manner that can still convey confidence in their ability to trust you. Now, looking at these disclosure forms, let's briefly go through them. On the patent side, you may be wondering about why do we need all the information on the inventors? And one of the reasons for this is we need to disclose every single inventor that contributed to the subject matter of the claims. Now, that's kind of a long-winded phrase there, but in short, if they contributed to something that now is the basis for the protection of the invention, we need to make sure that we actually include them as a known inventor. The background sections, you have what problem was solved, what were the issues. That kind of gives you a little bit of context as to what went into the invention that actually resulted. The next background section, what documents, publications relate to the invention, what presentations relate to the invention. This all deals with one main thing, prior art. We want to know, we want them to set the stage as to what the prior art is out there. And in particular, we then want them to be able to, when we talk to them orally, point out how it is that their invention is different from this context of the background that they are indicating. Well, the next section is just description of the invention, and this is where they simply provide details about what it is that they have actually come up with. Uses of the invention, how do you intend the invention to be used? Now, this kind of looks a little bit more into the future because obviously, let's say that somebody looked at a location tracking type system. And this actually, there was a client that came to our clinic who had a location tracking device system because his mother kept on losing her keys. So he came up a way where whenever the keys went out of a set proximity from the cell phone or from the actual tracking device, it would automatically do two things. One, it would record a video of the surrounding, and two, it would record a small audio clip. That way, later on, they could say, oh, this was the last place at which the keys were found. You could hear the audio, you could see the brief video to get contextually where it is that that was actually found. So, but the reality is the use of the invention, that might be an intended use for that particular person. But use looks at much more than just that particular person, and you look at how what others use the invention. So this looks at it almost from an intended or potential infringement point of view down the line. So how would, let's say, a person 10 years from now actually use the invention? Well, let's see, if they were doing that rather than having a standalone device, it might be integrated directly within the phone. Or we might have some type of, at that point, we might have a fabric of IoT devices within the home, the Internet of Things home, all which are communicating with each other, and any of those devices or conjunction of many of those devices could be working in harmony to actually target where it is that where the thing was actually found. So when you're looking at intended use, it's one, what is it doing now? But two, how would others actually use it, and how would they use it in the future? So this gets an inventor thinking a little bit outside of the box as to how it is that that would actually occur. The rest of it, affirmation and all that, just we want to make sure that we have some context and that they indeed are what they say they are, the inventor of the invention. On the trademark side, the disclosure, again, one of the most important things is the first main box after the name, and that is date of first use of the trademark. We want to know if they are currently using this trademark in commerce. If yes, they need to provide details. If no, then the big question is, how are you going to be using it in the future? Because if they're not using it already, then the reality is that we won't be able to file a trademark for them. So this in-use requirement is something, and the reason why is, yes, you can go ahead and file a trademark application without satisfying the in-use requirement, and later on you would file a separate document that shows when it is actually being used. But the reality is that how it is that we operate as a clinic semester by semester, that would not necessarily work. you in essence would have this open trademark application that we would need to be following up with repeatedly and could potentially be held, pending open for a significant amount of time. It would continually would have to make sure that we're keeping it open and that we're putting on file whenever it is actually getting in use. In short, it's a management issue. So we make sure that that first use requirement is actually being met. Use of the trademark relating to will it be going on a particular product? Is this, for example, an athletic brand or an athletic line, or is it cosmetic? Or is it something that's going on high technology, laptops, things of that nature? So, and all that, trademarks again are governed, or I should say organized, by goods and services. So a mark or a name is actually tied to a specific good or service within the society as a whole. Ownership again just gets to the idea as to what it is or who it is or what, if it's a company, is actually owning it. All right, so I give you a little background as far as what to do during the actual invention disclosure meeting. Afterwards as well, you want to make sure that everything is on the same page. I recommend recording the audio of the disclosure so you can upload that so that there's some basis. There's a few questions at the end that I want to briefly touch on, and these are questions that actually do come up from some of our clients. The first is, when will I receive the completed product? We want to make sure, and I've indicated this before, that we are very upfront in setting the expectations of the client. So if you're meeting at a client disclosure, I think that a good goal from the client disclosure is that you have the prior art search completed within 3 weeks. And once that prior art search is completed, again, that could be either on the patent side or the trademark side, then the expectation would be about 4 to 6 weeks thereafter, the goal would be to have a completed application to the client for their review prior to filing. The goal would be, within about 2 to 3 months' time, being in a position to actually file their application. Now, with a typical law firm, they often will say, well, within 3 months, we will go ahead and file your patent application, and that is after the actual client disclosure. Nowadays, I find that time period actually has almost narrowed a little bit, where most clients are demanding that under a first to file system, that those items be filed as quickly as possible, usually within about 1 month's time frame. So the reality is that the clinic is going, from that perspective, is going at a little bit of a slower rate, and that is expected. But we want them to understand that this is a training ground where we train you based off of the work that you are providing to them. And so as a result, we recognize that it has taken a little bit more time, but the reality is that they're getting this for free. So in short, they are the payment for the services, if there are any that can be construed as such, would simply be through the time that it takes to actually get the completed product. The second is my IP worth millions? And I've even had some who have asked me if their IP is worth billions. And you have to be careful how you respond, because most actually do really think that their IP is worth millions or billions, that it really will change the world. And to a certain extent, who are we to think that it may or may not actually do that? So you have to be careful on how you respond. But what I would indicate here is that you do have some frame of context in responding. So what I mean by that is that if they're coming before you and they're saying, you know what, my invention is worth billions here, and I need to make sure that we get protection on file as soon as possible. And you can say, you know what, I can definitely agree that your invention looks interesting. As far as the marketability, I really cannot comment on that. But the reality is that you may want to also indicate to them that, although you may feel that it's worth billions, you just should probably recognize that the patent market right now is a little bit tough. And what I mean by that is that most IP is not being sold for billions. And the court system right now alone, if you win, and let's say that there is infringement, and you win anything, that's over a 1 million mark, you can rest assured that most companies will fight that vigorously, even to an appellate level. The rules right now are swayed against for example, patent owners. And there's legislation that is trying to rectify that. But the reality is that they need to understand that even if it is worth millions or billions, that the market is not necessarily indicating that that is how it is for most IP. So again, you can just simply respond there that the reality is that most of the market would not pay that type of money for IP. But that being said, if Facebook or an emerging startup adopts it and uses it and becomes the next, and actually becomes the next Facebook, then it very well may be worth a sizable amount if they actually go ahead and acquire the rights to that technology. The last one, I would say, is one of the most often issues that comes up, and that is, are you going to steal my invention or my name? And you want to reassure them that you are their legal representative. So when they come before you, keep in mind, again, if it's a corporate client, they already know that you are the legal representative. But for somebody that, if this really is their first time experience coming before you, they may be very nervous about disclosing certain information because, you know what? You have not signed an NDA with them. And this, I've had many clients that have indicated to me, well, I can't exactly tell you the details of what I've done yet because we're not under NDA yet. And one of the easiest ways to respond to that is that, one, an NDA is not needed. And then we say, well, absolutely it is. That keeps things confidential. And you can say, it's not needed for two reasons. The first reason is if law firms actually signed NDA, it would create contractual potential conflicts. Because now, what it is that I know for one client, I might not necessarily, may exclude me from having a contractual obligation or responsibility or relationship with another client. So it creates a contractual nightmare for firms to manage who has what NDA with which entity, what level NDA is it, can this partner even talk to this partner? And so we do not do NDAs, generally speaking, as law firms. And the reason why we don't do it is because, one, contractual nightmare. Two, it is simply not needed. Because we are, as their legal representative, we are under many layers of confidentiality requirements. So as a patent attorney, I'm under my responsibility before the U.S. Patent Office. I'm under, usually, generally speaking, I'm under federal laws when it is that I'm actually operating in my capacity as an attorney. And under federal laws, I have requirements to abide by confidentiality requirements. Under state laws, as an attorney, I'm also required to abide by confidentiality. So yes, an NDA is not in place, but the confidentiality requirements are even higher than what an NDA would even mandate. The second thing, or the third thing rather, that you could indicate is that as their legal representative, you are advocating on their behalf. And what that means is that you are prevented legally from actually stealing their invention or taking the invention or the name. That if anything, rather than going down the point or down the road of saying, well, even if I did take it, there would be legal ramifications. You usually don't even want to indicate that. And so you can simply say the law would forbid me and prevent me from ever doing that. So it's not even an option for me, even if I wanted to. So in short, with this disclosure, I would finish with what it is that I indicated. You want to get as much information from them as possible because if we have a faulty foundation, no work we do thereafter will really be complete. And so we want to make sure that we understand completely what it is that we have going on.